Ms. Sutton?
May it please the court. I'm Deborah Sutton with Sutton Law Firm, here representing Mr. Kuntakinte Holley against the Department of Revenue. His case presents three issues.
Would you like to reserve time for rebuttal?
Yes, sir. I'm sorry. 3 minutes.
3 minutes.
We have three issues for the court's determination today. One is whether the department was without personal jurisdiction. The second, whether the department failed to effectuate service of its notice of a proposed order, and then whether there was sufficiently reliable and detailed information to calculate support. The department has actually conceded in part as to issue 3, agreeing that the retroactive support, at least as to the time period, was incorrect. Mr. Holley maintains strongly that the calculation of support is incorrect in a number of respects, not only as to the retroactive support, but as well as to the ongoing support. The case basically stems from, and probably the most important piece of paper in this record from Mr. Holley's perspective, is found at record page 316. That is a certified mail receipt, as you will, and a review of that will show that there is a signature for the recipient, which is totally illegible. There is an address, which is nothing more than a squiggly line. And then the actual typed information on that page simply shows that there was a delivery in Bartow, Florida. No street address or anything. The record also is not clear what was delivered at all. So if we go to the statute, the department is required to show that Mr. Holley actually received their notice of intent to go forward with these administrative proceedings. It's our position that when the statute allows them this method of service, short of personal in-hand service, then they must follow what the statute says specifically. So in this particular case, we don't have something that shows that Mr. Holley signed it, that it went to his address, or anything along that line. When that happens, and the statute has the backup, if a person other than the addressee has received it, which here there's no evidence that it was Mr. Holley, so you would go to the follow-up, then it says that the department, not Mr. Holley, but the department, shall attempt to reach the addressee by telephone and confirm whether the notice was received. So the department has argued that after this delivery in Bartow to some person of something, that there is a telephone call from Mr. Holley that indicates, I'm sending you the financial affidavit and the parent information form. And that actually is received and is in the record. And so from that, they have then bootstrapped that therefore he must have been the person that got the paperwork, and he must have gotten the entire packet, and now he's actually on notice. Instead, the record doesn't support that. The record, if you look at the actual items that Mr. Holley sent back in March, it simply says on those, the parent information, the only notice to him on that form is that he's required to fill it out and send it in. There's nothing on those forms that tell him what they're going to do with it, that there's going to be a proceeding, whether they're going to go into the court or whether they're going to do something administratively. They're also, with regard to the form, and the department has pointed out, he didn't disclose an address or an employer's information. So all that the department had at that time was the information that his employer sent in, however they got it, and then they had this information from Mr. Holley. They take no action consistent with the statute because they're required to make that call and document, Mr. Holley said, I got the stuff. So when you look at the documentation in the record, the only thing that they document is that he called to say he was sending in the financial information. There's nothing in that 1 or 2 lines in the record that says the department did anything when they had him on the phone to say, by the way, did you get the whole packet? Tell us, Mr. Holley, what you got in the packet. Mr. Holley, be aware that these documents are coming, or Mr. Holley, let us confirm what your actual physical address is so that we can send those pleadings to you.
The statute requires all that to go on during that phone call?
What the statute requires is that they confirm whether the notice was received, and the department shall document the telephone conversation. So the only thing that this documentation did was document his statement that he's sending in the financial affidavit.
Which he received. Otherwise, you couldn't send it in.
Correct. But what we don't know is how he got it or from whom. We don't even know where in Bartow the packet was delivered. Did they deliver it to someone he lived with? Was he living there? Did they give it to a neighbor? The only thing that record page 316 shows us is that something was delivered to Bartow. And that's all we know. The department next then does a proposed order, does some calculations. They do not use any of the information or very little of the information that they have in doing those calculations. They mail it, it's returned, and then within 7 days they render the final order. In objecting to the calculation, putting aside for a moment that we maintain strongly that Mr. Holley was not properly noticed of the proceedings at all, when you go forward with the actual calculation, they had his information, they had employer information. Those items show payment of health insurance, payment of union dues. They show that he's paying 3 other support orders. There's a statement that this particular child is in and out of his home. All of those things were not taken into account, not only as to retroactive, but as to the ongoing support. The argument of the department is, but Mr. Holley never produced receipts of any of that. He was never given the notice of the hearing. He was never asked for those items. And there's nothing in the form that says once you disclose, here's what your health insurance is. There's nothing that says we're only going to count that unless you send in the actual documentation. And part of that actually comes from the employer. So when you look to say, did they have sufficient information to do that? They did. It just wasn't utilized. So it's Mr. Holley's position, again, very firmly, that this record does not support his personal service. In fact, even though these items come back, or that they have the receipt from the postal office, that record page 316, they actually still release the whole packet to the local sheriff's department to try to effectuate personal service. It comes back unserved. And that was done at or about or following that receipt back. So the only thing, the closest that the department has to any service on Mr. Holley is just simply record page 316, and then later the financial document coming back saying, well, it was in the packet and therefore he must have gotten the entire packet. I just don't think for personal service process or for due process that it's sufficient to bootstrap and to go to that extent when we don't know here at all any more than what we do from record page 316. So it is Mr. Holley's request of this court that the order of the department be totally vacated. Thank you.
Your Honors, I'm Tony Bernstein from the Attorney General's Office representing Department of Revenue in this case. I guess the first issue is probably the most important, because if you find that Mr. Holley was correctly served, then all his other issues, I think, are moot because he didn't preserve them for appeal by raising them below. As to the personal jurisdiction, the department is allowed to serve by certified mail. At one time, we had green cards that showed the addresses and everything that went out. The post office has changed how they do certified mail, and now you get this printout that says what it says on it. So I mean, if it turns out that's not adequate, I guess, I don't know how that's going to affect any other situations where you're allowed to serve by certified mail. But even more importantly in this case, if you look at the record, you see every time the department printed out the notice of intent and the financial affidavit and parent information form with it, there was a new date on it. The forms that Mr. Holley returned to the department, the financial affidavit and the parent information form, both had the date of the notice that we're claiming that he received. If he didn't get all of this from the department, I don't know where it came from. If he had come in and they said, oh, you have to fill this out and run a new one, it would have had a new date on it. I mean, I think the record's pretty clear that he received the notice and the documents. And then he responded and returned the documents. Under the law, he was deemed served. There's no requirement that, as to the argument that service of the proposed order, that just has to be mailed to him at his address of record. 409.2563, parent 13 states that he has to keep the department apprised of any changes of address, and that he'll have been presumed to have received documents that are sent to his address of record. That was also in the notice. As to the reasonable evidence for the current support, the amount, the department relied on state wage information. One of the very cases cited by opposing counsel was the Gout case. It was not cited for the preposition I'm going to use it for, but in Gout, the court found that state wage information is reasonably reliable information on which to determine somebody's wages. As to Mr. Holley's health insurance, that was considered in the order. He did receive a deduction for the support that he claimed he paid for himself and his family, and a percentage of it was attributed to the child at issue in calculating the support, because they have to be put on different calculations. The health insurance for the child is added in. His union dues were considered. His other children, the court looked at what orders he had outstanding. And at that point, the only orders for child support that were outstanding were for arrears. That's not current support. That's not deductible from his gross income. That's support that wasn't paid, and now he's having to pay it, but it's arrears. As to a child that he's now claiming he's living with him, he didn't even put down a name. In fact, if you look at the financial affidavit, you'll see when it talks about deviations, he wrote NA. Mr. Holley's done everything he can to not give the department any information about his address, including not completing that section on the financial affidavit where it would have his address. His employer has the same address for him that the Department of Revenue used. I think that there's sufficient evidence in the record to support the finding that he was served. And as I said, once you find that he's served, he waived all his other arguments. And in all the alternative, as I have in my answer brief, there is evidence to support DOR's findings. So unless the court has any other questions for me.
You're still conceding what you conceded in the briefs?
The retro is wrong. When Mr. Holley filled out his form, he put down the wrong year. So yeah, we've conceded on the retro. It needs to go back to have the retro recalculated. Under Salter, even if we didn't have the wrong period, under Salter, because DOR had the state wage information for the retro period, they were required to use his actual income, even though, I mean, I was the attorney on Salter. My argument at that point was the statute says that you use current support unless the litigant requests that you use his current income, and the court said, oh, wrong, oh, wrong. DOR, as the trier of fact, had the information in their file, so they were required to use it. So yeah, we concede that the retro period was wrong and the retro support amount was wrong. So no other questions? I guess I'll rely on my brief. Thank you.
Thank you very much. Ms. Sutton, you have 3 minutes.
Just briefly, Your Honor. The department is saying that the notice went to his Bartow address. So again, it's our position that even if we presume for a moment that he got something in Bartow, whatever address they used, we still don't have a way to tie it to where Mr. Holley was. We don't know where that got delivered other than to Bartow. So if he was at 123 Oak Avenue instead of the address, and the postman delivered it there and said it went to Bartow, Mr. Holley should have been getting everything at that address, not the address where they believe that he was or where they're presuming someone served him. Because that notice came back with only Bartow, then we just simply don't know anything past that in terms of his actual receipt. And again, while the department is saying if he got these 2 pieces of paper, he must have gotten everything else, that's not sufficient for due process purposes to then say to Mr. Holley, where everything else in this record says it came back or we couldn't locate him, that we then straddle him with substantial arrearages and substantial monies when there's not been due process. So again, we would ask the court to vacate the administrative order. Thank you.